Good evening from New York. I'm Chris Hayes. A deeply divided Supreme Court today found a heretofore unrecognized right to the exercise of religious conscience by for-profit corporations. Writing for the all-male 5-4 majority, Justice Samuel Alito ruled that private for-profit corporations, the Hobby Lobby craft chain owned by evangelical Christians and Conestoga Wood Specialties Corporation owned by Mennonites, can opt out of paying for the kind of insurance coverage that would provide all FDA-approved methods of contraception for their female employees. The four specific methods of birth control those companies objected to do not terminate pregnancies or cause abortions. But the court ruled the companies' sincerely held religious belief that they do is enough to exempt them from federal law. In a stinging 35-page dissent, Justice Ruth Bader Ginsburg called it, quote, a decision of startling breadth, declaring that, quote, the exercise of religion is characteristic of natural persons, not artificial legal entities, and reminding her colleagues of the importance of women's autonomy in this area, she quoted the 22-year-old decision that reaffirmed women's right to abortion in this country. The ability of women to participate equally in the economic and social life of the nation has been facilitated by their ability to control their reproductive lives. It is precisely that control that critics of today's decisions believe was sacrificed by the 5-justice majority, with Samuel Alito writing for them. Joining me now, Ilyse Hogue. She is president of NARAL Pro-Choice America. Ilyse, I've heard two different kinds of reactions from people that are on the other side of this from you, so I want to walk through them. One is, this is not about birth control. This is about religious freedom. It's about narrowly construing a statute to protect the religious exercise of the family that happens to own Hobby Lobby. Birth control shouldn't be at the center of our understanding of this case. What do you say to that?
I think it's fundamentally about birth control, and in fact, it's more than that. It's about 5 male justices actually saying that discrimination exclusively against women in our healthcare system is not discrimination at all, and that's deeply disturbing. Look, Chris, we all value religious liberty. It's one of the values our country was built on, but what we don't value is the idea that anyone, much less our boss, can impose their ideology on us and us alone. And in this case, it was very specifically not just about birth control, but about very specific kinds of birth control that these bosses said they're not going to give their employees, even though the employees pay for that health care coverage with their own wages. And I think it's a sad day for women. It's a sad day for equality. And quite honestly, it's a sad day for religious liberty and the Supreme Court.
So the other way that I've heard people respond to this, people who aren't in sort of the zealously pro-Hobby Lobby camp, is basically, okay, groups like yours, like NARAL and Planned Parenthood, are making too much of this. I mean, women can get contraception if they need it. It's not that expensive. ACA still will provide it to most women who are covered under this this mandated coverage. Is that true?
No, it's not true. Actually, I think there's both a tangible concern, but there's also a moral concern. The tangible concern is that these particular types of contraception that they're objecting to are actually, somebody ran the numbers today, amount to a month of wages for a low-wage worker.
Wow.
You're asking that worker to pay twice, and this may be the very kind of contraception that works best for them and their families. So tangibly, tens of thousands of women's health coverage hangs in the balance with this decision, effective immediately. Those stories were not heard in the courtroom. It was all about the CEO of Hobby Lobby and his moral conviction. And then from a moral perspective, we're talking about basic fundamental equality, equality to make our own decisions about what we purchase with our own compensation packages. I think that goes to fundamental freedom, and I think that the court's decision should send a chill up all American spines.
Justice Alito, writing for the majority today, essentially limited the holding to what he called closely held corporations, which sounds like a small group. It's basically, I think, 50% of shares owned by less than 5 people. That covers as much as 90% of American businesses and, interestingly enough, about 52% of the American workforce. The court today, however, did leave open the possibility of the government, the federal government, actually directly paying for the women who would not have coverage via this decision. Is that something that NARAL and other groups like them will be advocating for as the fix in the upcoming weeks and months?
Well, absolutely. I mean, we think no woman can be left behind. The Affordable Care Act went a very long way in making sure that women were covered equally in terms of our health care options. And we're looking to Congress, we're looking to the administration to make sure that that promise holds true. We also think it's really important that voters understand where their elected representatives are on this issue. 99% of women in this country use birth control at some point in our lives, and this is a very mainstream concern. It's an economic concern, it's a health concern, and voters need to know where their elected officials stand.
By that you mean specifically on the court's Hobby Lobby decision today?
On the court's Hobby Lobby decision and whatever remedies are being promised to the women left behind. Absolutely.
Ilyse Hogue from NARAL, thank you so much.
Thank you.
Today's extremely